This is Your Money, Your Wealth.
And welcome to another edition of Your Money, Your Wealth. My name is Joe Anderson. I am a certified financial planner, president of Pure Financial Advisors. I'm with, as always, the big man, Big Al Clopine. We'll be talking to him shortly. Let me ask you a quick question. We have a great show lined up, but it's based on things that a lot of you don't have. Question number one, do you have an estate plan? Question number two, do you have any idea what an estate plan is? When I say estate plan, most people think about what happens when you die. And so don't worry about it. Over the next half hour, we're not going to be doom and gloom and talk about death, disability, dismemberment. Maybe we will, but it's very important stuff. So that's what's on my mind today. Latest study came out, 64% of you do not have an estate plan. What an estate plan is just a written documentation of letting someone know what happens to your stuff, to you, if you can't act for yourself. So either you die or you're disabled. Now, there's a lot of important documents here that a lot of you are probably unaware of. There's simple things that you can do to make sure that your financial house is in order in case something bad happens to you. This is big stuff because a lot of you have accumulated a lot of wealth, or maybe that you have loved ones, kids that you want to make sure that are taken care of if you can't take care of them on your own. So let's kind of dive in. Let's bring on my partner, Big Al Clopine. Big Al, let's talk about death, buddy. What's going to happen when you die? Or maybe you fall off a ladder and you can't necessarily do the things that you want to do.
Well, I'm just sitting here thinking this is such an important topic, but to talk about death on Saturday morning, I don't know, something seems wrong with that. But we're going to do it anyway because this is important. There's things that you guys are missing. And we're going to go over 4 main mistakes that Joe and I see over and over again in our practice. And number one is kind of obvious. You're delaying the process. A lot of you don't have a will. You don't have a trust, and you need one. There's a lot of reasons why you need a trust. It's not just for your loved ones after you pass, but while you're living. You need health care directives. You need financial powers of attorney, and so forth. Number two is for those of you that have a trust. You've set up a living trust. You've done the right thing, but you forget to put your assets in the trust. It doesn't do you much good. The next one is estate planning, and for those of you that have estates in excess of about $5 million, you have an estate tax problem, or I should say your beneficiaries. Your estate has an estate tax problem. We'll get into that. And we also want to talk about a lot of mistakes we're seeing with regards to beneficiary forms. And to kind of illustrate this, I think we've got a clip.
Only 1 year after my father passed away, we learned that the beneficiary form was apparently not filled out correctly and that we would not be receiving the money from the IRA. What he did wrong was not list our names individually on the beneficiary form. When you write, as per my last will and testament, is apparently not a proper designation as to where the funds will go. I had no idea that a will could be trumped by an IRA beneficiary form. I was shocked over that fact. My father never intended this. He would be so angry. He would be so mad.
This is common. When it comes to the beneficiary form of your retirement account, so your 401ks, IRAs, 403bs, TSPs, whatever, there's trillions of dollars sitting in these accounts. It's one of the largest assets that people have, and you want to make sure that you name the appropriate beneficiary. You might say, well, here, I have a trust, I have a will, I've documented everything in that legal document, but guess what? The beneficiary form trumps all. So you want to make sure that you update the beneficiary form. In that clip, Al, she was looking at, hey, well, it went to someone else, but he told me that it was going to go to me and my siblings.
Yeah.
But in his will, it had, okay, well, here, I'm going to have my assets go to my spouse. And I don't know if they showed that, but he was just married for a couple of months, so I don't know if she was hanging around the hospital beds.
Well, and that, yeah.
It was like looking at IRA statements and then decided, hey, you're a pretty good catch. Let's get married.
I mean, how many times have we seen the beneficiary statements? They're off. They're wrong. You may have your parents that are deceased, or you may have a spouse that you got divorced from, and she or he is still on that beneficiary form. Now, you had no intention of those assets going to that person, but that's exactly what happens. So, Joe, let's really get into this right now in terms of what these mistakes are that we're talking about. And the first one, as I mentioned, is people are delaying the process. And think about why are you delaying the process?
Because they're thinking it's about death. No one wants to talk about it. It's like, as soon as I set up the estate plan, what's going to happen? I'm going to die.
Yeah, I know. That's exactly why we don't want to do it. And some people realize, you know, they don't realize how important it is. Or some people think they're just not wealthy enough to need an estate plan, and the truth is everybody needs an estate plan. We would say this: if you're 18 years and older, you need an estate plan. And it doesn't have to be complicated. For some of you, it can be a will. For some of you, it can be a trust. And, but you got to have one. You got to set one up. And I guess one of the first questions we get is when we talk about an estate plan is, what is an estate plan? People don't know what it is. And really, it's setting up a will or a trust. That's your starting point. We're going to talk about pros of a trust over a will in a second. But it's more than that. It's setting up power of attorney. It's setting up medical directives. It's making sure your beneficiary statements are correct. These things are so important at any age to make sure you have correct.
Yeah, well, let's just use a couple quick examples. So when you think, all right, I need this elaborate estate plan, I got to hire an attorney and spend thousands of dollars on the plan. No, that's not the case at all. If you have any assets whatsoever, if you're 18 years of age or older, right, you want to make sure that you at least have a financial power of attorney and a healthcare directive. But let me use this as an example. When you look at, let's say, a financial power of attorney, why is this so important? Let's say that I have money in my 401k plan. I drive out of the studio this morning. Big Al is upset with me because I hogged all the camera time, and he runs me over, right? So he runs me over and he kills me, and so I'm dead. So I have this 401k plan, and let's say that I have Junior at home. Okay, so I have $500,000 sitting in my 401k plan. So my sole beneficiary is my son, who's 5. Or maybe he's 10, it doesn't matter. He looks at he mourns for a couple of minutes, but then he sees this statement by Charles Schwab, and he goes, wow, look at this, now I'm rich. Dad was rich, now I'm rich. I have to make sure that that beneficiary form is set up correctly. Now, if I die, that's easy. But let's say that I don't die. Now I'm in a coma. Okay, Junior still needs to eat. Junior still needs to provide a lifestyle for himself, but I'm still alive. I'm not dead. So he's not the beneficiary. I'm still alive. So how is he going to get access to the money? Is there financial powers of attorney? Is there executors in place? Is there guardians in place? Simple, life happens all the time. You just want to make sure that you're prepared.
Well, you do. And let's talk briefly about whether you should have a will or a trust, really. And if you think about it, it's like, well, do I really need a trust? And I would tell you this, a trust, what it does for you is it helps avoid probate. In fact, it does avoid probate. Probate is simply the process through the court that the assets go to the next generation. When you have a trust, it happens orderly with your trustee. There's a quicker disposition of assets, and it's private. It's not a matter of public record.
Yeah, well, that's all a trust does. Sometimes people think, well, if I set up this trust, a living trust, well, then that's going to avoid all sorts of taxes, and I can escape from creditor. No, all it does is avoid probate. And then there's ancillary documents within an overall estate plan, such as healthcare directives, financial powers of attorney, HIPAA releases, a living will, a pour-over will. I mean, it depends on how elaborate that you want to get. But a trust itself, all it does is avoid probate. So remember, you're dead, so it's your kids. It's the heirs of what you really want to make sure that you protect. We got a lot more to talk about with this. Sometimes think, oh man, I don't have enough wealth to have an estate plan. No. Everyone that's watching this program just about needs an estate plan. If you want to come into our office, we'll give you a full rundown, a financial assessment to see what makes sense for you. It's absolutely free of charge. We're a fee-only financial planning firm. We don't sell products. What we do is give advice. Estate planning is a key component of your overall financial life. Make sure you don't mess this up. Call the number, 888-994-6257. When we get back, we're going to dive into some examples. Sometimes, all right, well, if I go to probate, how much is that going to cost me? It's expensive, so we'll be back in just a second. Show's called Your Money, Your Wealth. Hey, welcome back to the program. Show's called Your Money or Wealth. My name's Joe Anderson. I'm a certified financial planner, of course, with Alan Clopine. Thanks for tuning in here until 11:30 on your Channel 4 cable station. Thanks for tuning in. We're having a lot of fun here talking about a pretty serious topic. When it comes to death, when it comes to disability, are you sure that you have the estate plan in place? Before we went to the break, we had a true-false question. Let's see how you did.
If I want my affairs to remain private after I pass away, I need to set up a living trust versus a will.
Yeah, and that answer is, I don't know what the heck that was. That sounded like
I'm not sure if that's
a duck.
That sounds true.
Yeah.
It's generally true, right? So here's the thing, is if you have assets of less than $150,000 in California, it doesn't really matter. You're not going to go to probate. And what probate is just going to the court. So your kids, the executor has to go to court to figure out where the assets are supposed to go to, right? That's what probate is. Assets are less than $150,000, no probate, it's not public. But if you have more than $150,000, it does go to probate, and so it's a matter of public record. So if you don't want to have your affairs public, then you need a living trust. And this is a reason why, Joe, a lot of people do get living trusts, just to remain private.
Yeah, well, I mean, there's a couple of different techniques that you could use. You could put your kids on joint title of your property. So any real property that you have, how do you avoid probate in that situation? You can just put junior on title. We recommend that you don't do that because then your kids could get involved in lawsuits and things like that, and then your primary residence or your property is kind of held. I know your kids are perfect angels and nothing will ever happen, but Al and I have been doing this long enough where we've seen issues like that. IRAs, of course, and 401ks, that will never go through the probate process because you have an IRA beneficiary designation. So they will go directly to those people. That trumps any type of estate plan. Al, before we get to this, I want to talk about two different things that I think are really important that we talked a little bit about before the break, is that you need to make sure that you get, if there's anything that you get out of this show, get a financial power of attorney and a healthcare directive. Absolutely critical. It will cost you $150. It is not that expensive, and I'm telling you, you have a 70% chance of something happening to you from a disability, or if you just get knocked out for a couple of hours. It doesn't matter. You want to make sure that you have those documents. Like I said before, a financial power of attorney. Sometimes if you're married, one spouse has a large 401k or an IRA. The other spouse does not have access to that money without a working financial power of attorney. IRAs and 401ks are separate property. You want to make sure that you have a financial power of attorney there. Death is easy when it comes to transferring wealth, but if you're disabled just for a very short period of time, that's where it gets really ugly. Because then what happens, the spouse needs to go to court to get conservatorship, and when does that spouse need the money? Probably right away. Another thing, when a healthcare directive, all I usually have to say, Al, is the name Terry Schiavo. I don't know if you guys remember that mess, right? She's in a vegetative state. The husband's like, no, she wants to pull the plug. Her family saying, no, we want to make sure that she's taken care of and everything else. So what happened? It drained the wealth of the family because they didn't take the time just to put some normal documentation. It is so important. So a healthcare power of attorney, financial power of attorney, make sure that you get those drafted as soon as possible. Let's talk about probate a little bit.
Well, we do need to talk about that because probate's actually pretty expensive, or can be. So why don't we go through an example here. If you pass away and have a few assets, and Joe, I know you're going to walk over to the board over here to kind of illustrate, but let's just go over a simple example where you own a home and maybe it's worth around $600,000 or so, and you've got a mortgage on it of $400,000. So maybe you have $200,000 of equity, and your retirement accounts are about $200,000. So you have a $400,000 net worth. And that really is not where probate starts. If we go to the next slide, probate actually starts on the gross value of your assets. Which
right.
means,
I mean, this is key because this is the problem. When you take a look at what's going on out here, is that if you got right, so $200,000 is the home equity, but my house is worth $600,000. If you have $1 million home with $1 million note, right? When you look at probate costs, it's not going to be based on what the equity is. It's the gross value, Al.
Yeah, that's exactly right. So in this example, we've got $600,000 home value plus a retirement account of a couple $100,000. So probate is going to be based upon $800,000. And how much do you pay? How much does your estate pay for probate fees? Well, it can be a lot of different figures. We're illustrating 5% because that's a common amount, although it could be all over the board. But that would be about $40,000 that your estate is going to have to pay. Now, if you have a living trust, there is no probate. The assets get distributed in accordance to your trust, and there's no worrying about this court case, the court fees, the attorney fees, and on and on and on.
So a few different things to take a look at in this real quick example is that we looked at, all right, the $600,000 value, you have $200,000 of retirement accounts. Now, if there's no designated beneficiaries on those retirement accounts, those will go through the probate process. It will go to the estate. And so the estate then has to distribute the wealth, and that will do it through probate. If you have a designated beneficiary, check the form, because then that will avoid the probate process. So you can just take this $200,000 right off the equation. So then you're only looking at $600,000. But a lot of you haven't checked the designate or your beneficiary form. All right, so make sure that it's updated. You want to make sure that you have a human being, right? We call it the heartbeat test. All right, if you can fog a mirror, then that's perfect, because they're alive. If they are an entity or it's in a state, that is not a good beneficiary. If you ever have problems thinking of a good beneficiary, Joseph Anderson is a good name. You can just put that on there, and trust me, it will get to the right person. So here's the deal, $800,000 gross estate, and then $400,000 is what you're going to end up paying, or $40,000. That's a huge number, and then guess what? Where's that money going to come from? The kids are either going to have to sell the house, or they're going to have to pull it from the retirement accounts. Al, what's going to happen when they pull that $40,000 from the retirement account?
Yeah, it's a good question, because the kids have to pay taxes on that. So clearly, they're not going to get that $200,000 out. It's going to be something much lower. Now, going on to our next point, and that is, you've done the right thing. You set up the trust, but then you forgot to put the assets in the trust. And what I mean by that is you have to change the title. So if you have a checking account, you have a savings account, you actually have to change the title to the name of your trust. If you have a brokerage account at TD Ameritrade or Schwab, you got to change that account. Or real estate, you have to go down to the county and record it in the name of your trust. Don't worry, this is what we call a see-through entity. So there's no difference in how you can use those assets, but they just have to be titled in the trust for you to avoid probate.
Right. Well, I mean, the whole purpose of setting up a living trust, it's an entity, right? So you don't own the assets anymore. The trust owns the assets. So you want to make sure that that legal entity owns the assets, because then they can distribute. Then you set up a successor trustee. So you are the trustee of your trust. You're the CEO of your corporation, if you will. If you were to pass away, who takes over? The vice president now becomes CEO. And then you already set the bylaws. You tell the CEO that, or the coming in CEO of what you want to have happen. And they distribute the wealth perfectly to your wishes to the kids. Yeah, perfectly. It never works out perfectly. A couple of things that you want to make sure that you look at, especially with your real estate. Biggest mistake Al and I see is that you forget to put your real estate in the trust, all right? So if you refinance, a lot of times the mortgage companies is going to do what? They're going to take the house outside of the trust to refinance. Why? Is because the trust doesn't have a FICO score. You do. So they have to take it out, look at your credit. Okay, here we refinance. And then you have to put it back in the trust. That's one of the biggest mistakes that we see. You spent all this money to put this elaborate estate plan in place, and you die, and guess what? The house is going to go directly through probate, and then you have to pay all these costs. Come into our office. We'll give you a free financial assessment. We'll take a look at everything for you to make sure that you are on track for whatever goal that you're setting out for, but make sure that you don't fall into these traps that a lot of people do. Here's the number, 888-994-6257, 888-994-6257. Call. It's absolutely free of charge. You have nothing to lose here. Now, when we get back from the break, I want to get into a little bit more about what happens to IRAs if you don't set these up correctly when you pass. And then we have your email questions, of course, so we're going to get a hold of those. Do not go anywhere. We got a lot more to go. Show's called Your Money, and it's Your Wealth. Hey, welcome back to the program. Show's called Your Money, Your Wealth. My name is Joe Anderson. I'm a certified financial planner with Alan Clopine. He's a CPA. Thanks for tuning in. Wrapping things up, last segment, talking estate planning today. It's a very important topic because everyone's going to die, right? And so you want to make sure that you are set up appropriately when you do pass, or unfortunately, if you get disabled, that your financial house is still in order. Now, when you think about this, there's a lot of information that you want to grasp. And one of the things that I do is that I teach a financial planning course. It's a retirement planning course just all over Southern California. So if you want to get more information, if you want to sit down and learn all of this and figure out what you need to do on your own, I would encourage you to attend one of these courses. You can register at our website if you'd like, at yourmoneyyourwealth.com, yourmoneyyourwealth.com. There's a registration form right there. I'm telling you, if you want to learn how to put all of this into play when it comes to your taxes, your investments, your risk management needs, and of course, your estate plan, all of this is interrelated. And so the course walks you through on how to set everything up on your own. I'm a big believer, everyone needs a comprehensive financial plan, but everyone doesn't necessarily need a financial planner. So let's see, we're trying to empower you, we're trying to educate you. And so we did a true-false question before the break. Let's see how you did.
All right, let's see if you got this right. If I designate my 16-year-old grandson as my IRA beneficiary, he won't have to take his distributions until he turns 59 and a half. And the answer to that question is absolutely false. And I would say this is one of the biggest misconceptions about IRAs when you inherit them, and simply is this. When you inherit an IRA, and if you're not the spouse, if it's the next generation or brother, sister, you have to start taking the RMDs, required minimum distributions, right away. At age 16, at age 26, at age 40, it's not 59 and a half. Now 59 and a half is when you can start taking your own distributions out of IRAs without a penalty. But when you inherit an IRA, you have to start taking those required distributions right away based upon your life expectancy at that age.
Yeah, it's a big deal because if there's a lot of money in there, right? Here's the deal. Let's say that your 16-year-old son or daughter inherits that IRA. Let's say it's a large chunk. It's $1 million. And so your younger child inherits it. They really don't know what to do with the money, right? They're 16 years old. They have to take a required distribution based on their life expectancy. And guess what? If they do not take that required distribution, so they have until April 1st the following year after your death, so they have a little bit of time. But if they do not take that required distribution, there is a penalty of 50%, 50% tax penalty if they don't take the distribution. Now let me ask you this question. Do you think your 16-year-old daughter or son will know that? No, of course not. The IRS is just waiting for you to die with huge amounts of money in these IRAs, 401ks, and everything else, because they're going to make out like bandits. A lot of individuals do not understand these rules. The IRS is so convoluted, and now all this money is sitting in these retirement accounts just waiting to get blown up with tax. Here's another thing, is that, did you know, Al, that 80% of female will die alone? 80% of females will die alone. And
I've heard something like that, but that's a pretty exact stat. Where do you get that? What's your source?
Well, it's my